Bit louder.
Lastly, previous 2023 after a detailed 1 year, and also now we are the new advocate. Kindly, the matter may be listed on 26.
It is hearing.
No, Lordship, for order. Obliged. May I please, your Lordship? Lordship, with the consent of other side, I beg to mention item number 2 and 3. As my senior, Mr. D. Talukdar, is at Aijol bench.
D. Talukdar.
Yes, Lordship.
He has difficulty.
He is at Aijol bench. Aijol bench, Lordship.
Your name?
Miss P. Soikia.
Miss D. Soikia. You are in item 3.
Item 3.
You are in item 2.
Item 2, my lord. I mean item 2, my lord.
Okay. Mr. D. Bora, the counsel for the appellant in item 2. And MS
P. Soikia.
P. Soikia.
On behalf of D.
Counsel,
Talukdar.
on behalf of Mr. D. Talukdar, and counsel for the appellant in 3. Are present. Mr. MS A. Begum, the traditional public prosecutor for the respondent state, is present. Mr. MS Soikia, the counsel appearing on behalf of Mr. D. Talukdar, has prayed for an adjournment. As the prayer is not opposed by the learned counsel for the other sides, the prayer is allowed.
Obliged, Lordship.
I'll leave the appeals after 2 weeks.
It is for orders, I think more.
Sir, offense is under section 302, Lordship. Life imprisonment. I have filed a bail application, Lordship.
Yes.
Lordship, judgment is at page 34, Lordship.
Admitted?
No,
Not admitted.
yes,
Matter is admitted or not admitted?
it is admitted for hearing, Lordship.
Earlier it was listed before a single bench, Lordship. Now it is here, Lordship. And
First time in division bench, Lordship.
LCR is called for not admitted.
Not admitted. Lordship.
Not admitted.
This is the first time, Lordship.
Okay.
Before this division bench, Lordship.
Learned counsel for the accused appellant, and MS A. Begum, learned additional public prosecutor for the respondent state. First one. This appeal under section 374(2) Code of Criminal Procedure is directed against the judgment and order dated 12/9/2023, passed by the learned Sessions Judge Siva Hagor in Sessions case number 77 S/S/2017. Full stop. By the judgment and order dated 12/9/2023, the accused appellant has been convicted for the offense under section offenses under section 302, IPC and section 201, IPC. For the offense under section 302, the accused appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, undergo simple imprisonment for another 3 months. So for the offense in the section 30 or 201, IPC, the accused appellant has been sentenced to undergo imprisonment for 3 years and to pay a fine of rupees 5,000, in default of payment of fine, 2, undergo simple imprisonment for 2 months. So the sentences are ordered to run concurrently. So the appeal is admitted for hearing as the issue notice returnable in 4 weeks. As MS Begum and additional public prosecutor have appeared and accepted notice on behalf of the respondent state. Issuance of formal notice to the respondent state is dispensed with. However, extra copy memo will be as the case records from a learning trial court have already been received, office to prepare the paperwork. Yes.
For hearing paragraph method, item number 14.
Hey, follow this. হ্যাঁ লবি এখানে উপমাটি করে করে পল্লবী আধার পরীক্ষা আছে না AJ.
Oh, IO to PW9.
यहाँ पे
Put question for
So if a purchaser said now was in presence of witnesses and we two is the seizure. Exhibit 2.5 is my signature. Till exhibit 1 is the said down. I recorded the statement of the seizure witnesses, also the statement of the accused person. I arrested the accused person in construction connection with this case. Said down is seized in presence of witnesses.
witnesses.
আর ইমার কেটে কি করে সিজার ফোন বা ফুট MS Priya, where is the seizure list of Dow?
Page 55 and 56. 55 and 56. 55 is Machate, madam.
One, PW2, so PW3,
Exhibit pilot.
PW. Para 27 to লিখিব এইটো 28 এটা আছে হা 27 লিখিব
Then I'll-
কিন্তু একো কয় PW1 এ কয় আকৌ I do not know the contents of executive with two signatures. At the time when I put the signatures, it paper was ready. Lot of money was IO PW9. Is in chief, Pawan. stated that it was at around 6:30 PM on 14/2015, the informant this PW1 lodged the FIR EXT3 at Namrup Police Station regarding the incident. And the same was registered as Namrup Police Station. Case number 151/2015 under section 302 IPC. And he had already took up the investigation as he was endorsed to do so. The IO PW9 in his evidence in chief had further stated that it was at around 6:45 PM, the accused, Vishnu Orangia appeared in the police station along with the Dow. Full stop. Thus, at the time when the accused allegedly appeared in the police station, there was already a formal written FIR lodged against him for the charge of murder of his wife. Full stop. Chapter 28. There are about 28 to 29 level. The 30. Bio PW9 that as soon as the Dow was accused appeared in a police station with the Dow, immediately after, the accused appeared in the police station with the Dow, the Dow was seized in presence of witnesses. Provide a seizure list EXT2, wherein he identified his signature as EXT2 file. First of he recorded the statements of seizure witnesses who were PW1, PW2, PW3, and PW7. Full stop. PW7, comma. Odit Pegu was a constable posted at Namrup Police Station on the relevant date. Full stop. IO further stated that he recorded the statement of the accused person, and on the same day, comma, the accused was arrested. The prosecution witness, comma, that is the informant PW1 did not wholly support the evidence of IO on the seizure list, EXC2, as he had stated that when he put the signature on the paper, comma, the paper was blank, and he put his signature on on EXT2 when asked by the police personnel. Full stop. PW2 stated, comma, in his cross-examination, comma, to the effect that he did not go through the contents of EXT2 at the time of putting his signature, and he did not know why the police obtained his signature in EXT2. In a somewhat similar manner, comma, PW3 also deposed that he did not know the contents of EXT2. The prosecution witness, comma, PW7 deposed that he put his signature in the seizure list EXT2 when police seized the town wide seizure list by the seizure list within bracket EXT2, and he identified his signature therein as EXT 24. Full stop. PW7 testified that the IO PW9C is the DAO which the accused was carrying. Full stop. Thus, on one hand, the non-official prosecution witnesses as PW1, PW2, and PW3. When cross-examined, had deviated from what they had stated in their evidence in chief, subtly, SUBLY, on the aspect of seizure of the DAO and their and subscribing their signature in the seizure list, EXT. Full stop. Noticeably, the no entry from the general diary has been exhibited in support of the seizure of the DAO commander alleged weapon of assault. Proceed. It is noticed that when the prosecution witnesses PW1, PW2, and PW3 had somewhat deviated from their stand earlier taken evidence in chief, in their cross-examination on the aspect of seizure, the prosecution side did not choose to confront the said prosecution witnesses. Thereafter, the aspect of seizure was done. It was open for the prosecution even after the stage of cross-examination to confront these prosecution witnesses when they were seen to have deviated in such manner. It is relevant. It is apt to refer to the following observations made by the Honorable Supreme Court of India in Dahiya Bhai, Sagan Bhai Thakkar versus State of Gujarat, reported in AIR 1964 SC 1563, that's a fair. Wrong, A. To A. Original to
Oh, ক'ত কৰি দিব?
Yes, we have shown something about material exhibit,
Yes, the
not
other
shown
day I have shown my
the
lord.
doctor.
Yes, my lord, that was as regards
Which one is the other?
lordship. And 2017, 13 SCC 81. Sudhar Renukaya and others versus State of AP. I've got my.
আছিল লোক না আৰু দুটামান আছিলে এটা সঞ্জয় ঠাকুৰ আনসাৰ নাইকিয়া হ'ল 2017
Yes,
13 SCC
yes, your lordship. Para 35 to 37.
the autopsy doctor from our PW6. Opposed to the effect that the death was instantaneous following the neck injuries sustained by the deceased. Full stop. The injuries recorded in the PME report EXC6, where, according to him, where caused by a sharp cutting heavy weapon. Full stop. The alleged, in his cross-examination, he stated that the alleged weapon of assault was not shown to him. The defense has raised an issue that in the report given by the serologist, White EXT 11, had reflected that the alleged weapon of assault, the mid-dow was heavily rusted. Full stop. In such situation, it was obligatory on the part of the prosecution to show the alleged weapon of assault to the autopsy doctor to have his opinion as to whether the injuries recorded in the PME report, the injuries found on the body of the deceased, as reflected in the PME report EXT 6, were possible by such kind of rusted down. The decision in Sudha Renukaya and others, Supra, placed by the learned. The fact of the case in so and so, placed by the learned additional public prosecutor was that the weapon was neither shown to the autopsy doctor nor in the cross-examination was invited towards the weapon. Full stop. It was observed therein that non-swing of the weapon, the mere fact that the weapon was not shown to the autopsy doctor was not of much consequence in the facts of the said case, as there was clear medical evidence that the injuries could be caused by the knife, X and battle X. It was found therein that the eyewitnesses therein, PW1, PW2, PW3, and PW5 had clearly mentioned about the weapons used by the accused. And their eyewitnesses' accounts were in accordance with the medical evidence. It was in such backdrop, it was held that mere non-showing of the weapons to the doctors at the time of their depositions in the court is inconsequential, was inconsequential and was in no manner weakened the prosecution case. Question. Verification of documentation. Carta case. 1976. 1 SSC 170. 1970. 1 SSC 170. To the facts of the case, it is noticed that the alleged weapon of assault, MAT EXT1 was shown to the prosecution witnesses as PW1, PW2, PW3, PW7, and PW9. When they were examined in court, but MET EXT1 was not shown to the autopsy doctor when he was examined as PW6. The report of the serologist W 10
10 scientific officer.
given white
Page 76.
EXT given by the report the given by EXT
11.
11 report,
Gosh. Page 76.
comma it was desirable for the prosecution. And that the MET EXT1 DAO was heavily dusted, comma it was desirable for the prosecution to show it to the autopsy doctor to have his opinion whether the injuries sustained by the deceased were possible to be inflicted by MET EXT1 DAO. In Kartarey, KARTAREY versus State of Uttar Pradesh. Reported in 1976, 1 SCC 172. Comma. The Chura, the weapon, recovered from one of the accused was neither shown to the medical witness, nor his opinion was invited as to whether any or all of the injuries on the deceased could be caused with that weapon. it was in such context, comma, it was observed that the importance of eliciting the opinion of the medical witness, comma, who had in that context, it was emphasized. No, uh, it was emphasized that there was because in that context, comma, the Honorable Supreme Court had emphasized, Honorable Supreme Court emphasizing on the issue, comma, has observed that the importance of eliciting the opinion of the medical witness, comma, who had examined the injuries of the victim, comma, more specifically on the point, comma, for the proper administration of justice, comma, particularly in a case where injuries found are forensically of the same species. And the problem before the court was whether all or any of those injuries could be caused with one or more than one custom. It had been held that it is the duty of the prosecution, comma, and no less of the court to see that the alleged weapon of the offense, comma, if available, comma, should be shown to the medical witness and his medical opinion invited as to whether all or any of the injuries on the victim could be caused with that weapon. Full stop. It has been further, it was further observed that failure to do so might, comma, sometime, comma, cause aberration in the course of justice. Full stop. The informant PW1 testified to the effect that he did not stay with his parents at the relevant point of time, comma, he was not staying with his parents, comma, that is, comma, the accused and the deceased Full stop. As. It was his mother and his younger brother, Moina Orangia, who used to stay in the house, in the same house with his father, that is the accused. Full stop. From the testimony of PW4, it has emerged that PW4 was the first person to see the dead body of Mrinali Orangia. Full stop. The said witness, PW4, had immediately informed about the same to Moina Orangia, the younger son of the deceased and the accused, and the younger brother of the informant, PW1. Full stop. From the evidence of PW4, it has further emerged that Moina Orangia came immediately to the spot and identified the dead body to be of his mother. Full stop. PW4 stated that he came to notice the dead body. Dead body came to his notice when, after a football game, to the house of Moina Orangia to drink water. Full stop. The PW5 deposed was Moina Orangia, who informed her that his mother had been cut. From the testimonies of PW4 and PW5, it has clearly emerged that the Moina, the younger son of the deceased and the accused, Moina Orangia, was in the was either in the place of occurrence or in the vicinity of the place of occurrence when the dead body of the deceased Minali Orangia was found by PW4 post office. It was Moina Orangia, who used to stay in the same house with his parents, the deceased and the accused. Full stop. In such scenario, Moina Orangia appears to be the appears to be a material witness to depose about the events which had occurred in the house of the accused and the disease on the relevant day. Full stop. Conspicuously, the prosecution did not examine Moina Orangia as a witness during the trial. Despite listing him as a witness, the list of witnesses in the charge sheet, EXT 12. Full stop. When the IO PW9 was examined, he admitted that he had recorded the statements of Moina Orangia during the course of investigation. Full stop. In the facts and circumstances of the obtaining in the case in hand, we are of the considered view that Moina Orangia was one of the vital and material witness to depose about the occurrence as the dead body of the disease was found inside the house premises of the accused and the deceased, wherein he also used to reside. Full stop. In this connection, on the point of non-examination of a material witness by the prosecution, the following observations made in the case of Takashi Hiraji versus Thakur Kovel Singh Summons, reported in 2001, 6 SCC 140, near relevance. Para 19, Dr. Dothree, it is true for Amotri. Spectrum of non-examination of other witness. As we have found that the prosecution case is based on circumstantial evidence. Also, none of the prosecution witnesses had deposed that they had seen, prior to the disease meeting her date, the disease was in the company of the accused. Full stop. As the prosecution witness, PW4 had testified that it was at about 12:30 on 4/5/2015, he noticed the dead body of the deceased lying in the backside of the house on the relevant day, the deceased had met the death at an anterior point of time. Full stop. As per the PME report, EXC12, which was carried out at 45 PM on 5/10/2015, the approximate time of death was 24-36 hours earlier. uh, time of date approximate. As reflected in the PME report is considered, the date of the disease had occurred possibly in between the midnight of the day intervening 3/10/2015 and 4/10/2015 and 12:30 p.m. when her body was first seen by PW4. First seen PW4. Full stop. From such point of view, such standpoint, we further reiterate that Moina Orangia was one of the most material witness for the prosecution. First of para. Does, uh, no, uh, does, there is no evidence on the point of last seen together. To the testimony of PW8, Samuel Beck. First of, he told before the court that he was a tea garden employee. First of, on the incident, no, in his testimony, PW8 deposed that he knew the accused and the deceased as they were his neighbor, but he did not know the informant, PW1, who was their son, who is their son. He deposed to the effect that on the day of occurrence, at about 6:30 p.m., he was returning from Jaipur police station. He stated that while he was heading to Jaipur police station, he received a phone call from Namro police station informing him that the accused had killed his wife. Full stop. He further stated that while he was returning home, he met the accused along with a dao in his hand. And he asked him where he was proceeding. In reply, the accused told him that he was going to Namru police station and asked PW8 to accompany him to Namru police station. Full stop. PW8 further stated that the accused had told him that his wife, he had killed his wife. And so, and for that reason, he wanted to go to the police station. Full stop. It was then, PW8 taking the accused along with him, went to the police station. Full stop. In his cross-examination, he had diverged that the distance between Namru police station and Jaipur police station is about 10 kilometers. Full stop. He had admitted that he did not state before the police that while he was proceeding towards Jaipur police station, he got a phone call from Namru police station that the accused had killed his wife. He further stated that he did not state before police that while returning, he met the accused on the way. And he asked him to take, and the accused asked him to take him to Namru police station. So he has, however, denied a suggestion that he did not meet the accused carrying it out. And the accused did not ask him to accompany him to Namru police station. Full stop. The PW7 further stated that police did not record his statement. I will give a question for statement record probably. If entered with so far. Did I say recorded his statements or not? Ayo.
About Moina.
Oh, no. PW8.
Oh,
Up to one.
In the cross only, the IO says that the accused Vishnu Orangya was alone when he entered into the police station.
Did Ayo say yes or no?
No, madam, no.
Say anything positive or negative? Or silent? I asked that one only.
He was silent, my lord, on PW8, my lord.
PW
On PW8.
is 9 or PW8. Silent.
Yes, sir.
Is he a listed witness?
Yes, madam.
Samuel.
Samuel.
Yes, your lordship, he is a.
He's a witness.
Parsi.
Page 78, my lord, witness number 7.
78.
78, witness number 7.
The PW8. It is not. It has not emerged from the. It has not been explained by the prosecution as to why this witness, PW8. Neither a member of the force nor a member of the village defense party. A phone call was made from Namru police station to inform him that the accused had killed his wife. The version of PW8 was that he accompanied the accused. He took the accused, who was allegedly wielding a dao in his hand, to the police station. Full stop. PW7, Ajit Pegu was posted as a constable at Namru police station on the relevant day. Full stop. In his testimony, PW7 stated that at around 7 p.m., the accused person, accompanied by a village defense person of Udaipur village, came to the police station in a bike, and the village defense party personnel told him that the person who was with him had killed his wife. Full stop. PW7 further testified that he saw the accused person carrying a dao in his hand. Full stop. When the testimonies of PW7 and PW8 are read together, it is not, it does not emerge that, does not emerge clearly that it was PW8 who accompanied the accused who was allegedly wielding a dao, to the police station. Full stop. As PW7 did not disclose the name of the village defense party personnel. We'll come back. What was his reply in 313?
Matlab
Says
question number
32.
132, question number 1 only, madam. I do not know about my wife's death. I was taking care of the cattle, and when I heard, I immediately went to the police
Page,
station
page.
along with the town.
Page 32, your lordship.
Page 32, madam. Question number 1.
The case led by the prosecution to the witnesses to fix the culpability on the accused is to bring a chain of circumstances. But without the last scene theory. Full stop. The prosecution has not been able to bring anything on record to even suggest that the disease was lastly seen with the accused. Full stop. The last scene theory is applicable in a crime based on circumstantial evidence. When the crime was carried out in secrecy and in absence of eyewitness. Full stop. It is a settled proposition that when the time gap between last scene and time of occurrence is long, it is unsafe to base the conviction solely on the last scene theory. And in such circumstances, it is always safe to look for corroboration from other circumstances and evidence adduced by the prosecution. As the case in hand is not a one of last seen theory together with the other circumstantial evidence. A question of shifting the onus on the accused to explain how the incident occurred and what happened to the victim was not seen with him lastly is not applicable. Full stop. A case based on circumstantial evidence together with last seen theory, failure on the part of the accused to furnish any explanation in this regard, or explanation gives rise to a strong presumption against him and in favor of his guilt, and would provide an additional link in the chain of circumstances. Full stop. It is also settled that in the absence of proof of any other circumstances, the only circumstance of last seen together and absence of satisfactory explanation cannot be made the basis of conviction. Full stop. When the prosecution does not put forward the last seen theory, mere non-explanation on the part of the appellant by itself cannot be the basis of proof of guilt against the appellant. Full stop. The failure of the accused to offer any explanation in his statement under section 313 CRPC alone is not sufficient to establish the charge against the accused. Full stop. It has been held in State of Goa versus Sanjay Thakran, reported in 2007, 3 SCC 755. That in the absence of in the absence of any evidence on the point of last seen together, the accused person, apostrophe persons, not giving any explanation in their examination under section 313 could not be taken to be a circumstance pointing towards irresistible conclusion that he is involved in the commission of the crime. এটা পেৰা থৈ দিব মাজত মাৰ্চত পেৰা the testimony of the deposition of informant PW1 who did not stay together with the accused Commander Disease and Moina Rangia come up on the point that the accused was not favorably disposed towards the disease and Moina Rangia cannot be taken into consideration when the best person to depose on the point would have been the person who as Moina Urangia would have been the best person to depose on such aspect. First of in the case of in a case based on circumstantial evidence, what is the duty of the prosecution to bring home a charge on the basis of circumstantial evidence has been succinctly has been elucidated in the case of Sarda Bedisan. Sarda Bedisan. Personally.
Sarda.
Yeah, what we are really good. When the accused was examined, when his explanation was asked for during examination under section 313 CRPC, the accused had accused stated that he did not know about his wife's death. Full stop. As he was taking care of the cattle. Full stop. As soon as he heard, he stated that as soon as he heard about the incident, he immediately went to the police station along with the dog. Full stop. Sarad Bidichan Sarda versus State of Maharashtra. Reported in 1984. 1984, 4 SCC. 116. 153. Or down hole, paragraph 153 to below. 158, 160. Paragraph, huh? 3, 158, 159, and 160. পঞ্চশীল বুলি ক'ত ক'লে? পঞ্চশীল বুলি ক'ত কৈছিল?
Sarda Bedison.
Sarda Bidichan পঞ্চশীল যে কৈছিল।
Pasta creation.
Pasta. Ni 53 পৰা 153 পৰা 160 যে মাই ক'ত কৈ দিব মই দি দিম। 53 পৰা 160 মই কাটি দিম। It is true that the blood group uh, found Honda seized down matched with the blood group taken from the blood group matched with the blood group of the samples, blood samples taken out of the body of the disease at the time of post-mortem examination. As the serological test gave positive results for human blood group, human blood of a particular group. Full stop. But the same could only be taken as a link in the chain of circumstances. So, in view of first of all, the fact that the accused had appeared, even if it is accepted that the accused had appeared at the police station with a blood stain down, the same is also not such a circumstance which can in itself, which can be treated as a proof of the fact that it was the accused, it was he and he only who had killed the deceased. Full stop. Questions I have made above on appreciation of the evidence on record in its entirety, and for the reasons mentioned above, we are of the considered view that the chain of circumstance is not found to be complete to the hypothesis of guilt that is in all probability, comma, the accused, it was, huh? Who had committed the crime. It is in absence of various links. In absence of cogent, reliable and concrete evidence. To link all the circumstances. It is unsafe. Return a finding of guilt against the accused. Yes, full stop. Uh, in the above fact situation obtaining in the case, comma, we are of the considered view that the evidence stroke materials on record was not sufficient enough to hold that it was none but the accused appellant who had killed the disease, full stop. Situated in such situation, comma, we are of the considered view that the accused appellant ought to have been accorded at least the benefit of doubt. Full stop. In the as a result, comma, we are of the considered view that the impugned judgment and order of conviction and sentence passed against the accused appellant is not sustainable in law. Full stop. Consequently, comma, the appeal is required to be allowed. Full stop. It is accordingly ordered by setting aside the conviction and sentence passed against the accused appellant. Full stop. The accused appellant is to be set at liberty if his detention is not required in connection with any other case. Full stop. A case, of course, of victim. The case records are to be sent back to the learned trial court forthwith. Yes, total diwari appreciation.
Lordship, other than make my submission, whether Moina can be called up and your Lordship may please to
Okay,
exercise.
BVR of the Divo, BVR of the point value submission. That prosecution made efforts to call Moina Aurangzeb.
Deeply obliged, your lordship.
In Amori president.
Twelve 30, pardon better.
এখানে লই যাব সামৰি থব Yes, I know. Son and nephew. Mr. Borua, we'll start the second innings at 2. Mr. Bhuya, you are waiting since morning.
For item number 5, it's a date reference, my lord. But the second half, Learned Senior Counsel is there as amicus curiae, Jet Kamar. So that APSC cases hearing is going on in Bhangagar, APSC Bhangagar. So it won't be possible for him also.
Maybe after vacation.
After
Fi-
vacation,
get a-
my lord.
Choose a fixed date.
Fixed date, Nirmala. Date to side, but
It will not be possible before vacation.
my question. Was site for this, no? First August? 1st August, my lord? First.
I will do. It was a little. রিপিট করে দিব আর নাম কেটা জেড কামার সিনিয়র কাউন্সিল এমিকাস একে ভুইয়া ম্যাস এস পড়া হ্যাঁ এস পড়া ফার্স্ট অফ আগস্ট
First, 2nd of August, my lord.
সেকেন্ড অফ আগস্ট আগস্ট রিপিট করব ডেট টু খালি সেকেন্ড অফ আগস্ট
Oblige.
Lordship, regarding the other matters, whether we should stay back for rest of the hearing matters?
you were there.
No, no. She'll be there in second half matter. And
Okay.
subsequently, we have matters, my lord. Should we wait or?
I don't think so. We have. Bora was there.
She's there
On the next
for
item.
the partnered matter.
Okay.
Other matters are also there.
If we proceed, I don't think it will be completed today. After the delivery of judgment in these two,
My lord.
if we hear also, it will not be completed.
So we may leave, my lord.
We'll hear the appellate side. Better. As both the sides have extensively referred to the testimonies of PW 1 and PW 2. Come on. It appears, no, it is, their testimonies are required to be, are found necessary to be considered at first post of PW 1, Sam, S-A-M, Chowra. Is the younger son of the deceased. Whereas PW2, Ojit Bhakta, Bhakta, Silo. Is a nephew of the deceased. Full stop. At the time of giving evidence, PW1 was 16 years of age, whereas PW2 was 20 years of age. Full stop. Subparagraph. In his evidence in chief, PW1 deposed to the effect that his mother, Bina Chawra, died on 10/7/2016, and he knew both the accused persons. Full stop. On the incident, PW1 deposed that on the night of occurrence, he, along with his mother and Fazil Bhakta, within bracket PW2, was sleeping in the interior room of their residence, while the two accused persons, Taklu and Monglu, were sleeping in the outer room of their residence after having party. Full stop. The accused persons who were sleeping outside in the outer room, came to his mother's room and held his mother to slit SLIT, slit her neck with a dowel. Full stop. Both the accused persons threatened them, that is, him and PW2, not to disclose about the incident, lest they would kill them. Full stop. On the following had gone away, but they, within bracket, he and PW2, were lying inside their house as they were terrified. Full stop. On the following, PW1 further stated that on the following morning, he went to his elder brother, Deepak Chawra's, within bracket PW6, house, who used to reside separately, to inform him about the incident. Then, his elder brother, PW6, came to the house and found their mother dead. Full stop. Deepak Chawra, PW6, then went out in search of the accused persons. Full stop. Later on, his brother, PW6, informed the police and lodged the FIR. Full stop. As regards the injury, PW1 stated that his mother sustained a cut injury on her neck. Police personnel came and examined the dead body of his mother and post-mortem examination. He stated that police also arrested the two accused persons and recorded his statement during investigation. Full stop. In cross-examination, PW1 stated that the accused, Taklu, was staying in their house for about 2 months. Full stop. He stated that he did not know if Ozit PW2 invited Monglu to stay in their house on the night of occurrence. Full stop. Time of occurrence, PW1 stated that the incident took place at about 2 a.m. midnight. Full stop. On his relationship with Ozit Bhakta, PW2, PW1 stated that Ozit Bhakta is his cousin brother and he had been staying with them for about 3-4 years. Full stop. He denied a suggestion put to him by the defense that it was Ozit who had killed his mother. Full stop. He acknowledged the existence of other households in the vicinity of their house. Full stop. He further stated that it was his brother, PW6, who had caught the accused persons and handed them over to the police person. Para. PW2, Ozit Bhakta also deposed that he knew both the accused persons. The disease, Meena Chawra, is his Burma item. Who died in the month of July. Full stop. He stated that on the date of the incident, he, along with Sam Chawra, within bracket PW1, and Meena Chawra, was sleeping in their residence, and the accused persons were sleeping in the outer room. Full stop. It was in the middle of the night, both the accused persons came to their room and caught Meena Chawra. Full stop. At that point of time, they woke up and saw the accused, Monglu, slitting the neck of Meena Chawra Uchedao. PW2 stated that his aunt, Burma, within bracket aunt, died. Full stop. PW2 corroborated the testimony of PW1 by stating that the accused persons threatened both of them not to disclose the incident to anybody, else they would kill both of them. Full stop. He further stated that as both of them were terrified, they were also lying. They were also lying in the room, as the accused persons were in the house for the whole night. Full stop. PW2 further stated that in the morning, Sam Chawra, PW1, went to the house of his elder brother, Deepak Chawra, PW6, who used to reside near their house, to inform about the matter. Full stop. Deepak Chawra thereafter came and saw the body of his aunt Burma, body of his mother. Thereafter, the matter was informed to police by Deepak Chawla. He further stated that police personnel came and took the dead body with them. Also apprehended the accused persons. He stated that his statement was recorded by police during the investigation. During cross-examination, PW2 stated that the accused, Taklu alias Siva, was staying in the house of Sam Saura PW1 for about 2 months from the time of the alleged incident. Full stop. A suggestion was put to PW1 to the effect that it was he who called Monglu to stay in the house of Sam Saura PW1 on the date of the alleged incident. And say suggestion was categorically denied by PW2. Full stop. On the time of, as regards the time of occurrence of the incident, PW2 stated that the alleged incident took place at about 1 a.m. midnight. Full stop. He further stated that after the incident, they, all four of them were in the same room. The dead body of his aunt was lying also in the same room. Also. He further stated that both the accused persons were in the house till the arrival of the police personnel, as they did not try to run away. Stop. He further stated that he had no knowledge as to why the accused persons had killed his aunt bodily. Stop. He claimed ignorance as regards the seizure of the used by the accused persons, by police. The defense gave a further suggestion to this witness to the effect that it was he who had killed his aunt, Borma, and had falsely implicated the accused persons with the killing of his aunt by giving false evidence. In response to the said suggestions, the witness PW2 was emphatically in denial. From a combined reading, an appreciation of the testimonies of the aforementioned two prosecution witnesses, PW1 and PW2, it has emerged that both of them were sleeping in a room inside the house along with their mother and aunt on the night intervening. 9/7/2016 and 10/7/2016. Full stop. Both of them were categorical in their testimonies that both the accused persons were also in the house and they were sleeping in an outer room of the house. Full stop. The sketch map of the PO EXT 4 indicates that there were 3 rooms in the house. And the only house in the vicinity, the nearest house in the vicinity belonged to Sukru Saura within bracket PW3. It is at this stage, at this point, it is also relevant to refer to the replies given by the accused, Taklu, during his examination under section 313, CRPC. Also, in response, the accused, Taklu, had stated that he admitted that he was residing in the house of Sam Saura, PW1, for about 2 years. Full stop. He further stated that the deceased, Bina Chaura, was his aunt Burma. And on the relevant night, his aunt Burma asked them to stay in our house, and accordingly, they stayed for the night in the house of Bina Chaura. Full stop. The accused, Taklu, further admitted that they were sleeping in the outer room of the house, and his aunt Burma, Bina Chaura, Chom Saura, PW1, and Ozid Bhakto, PW2, were sleeping in the inside inside the room, which was the third room of the house. Full stop. when during his examination on the 313 CRPC, comma, the other accused person, Monglu, maintained silence on this aspect without offering any kind of explanation. Full stop. Para. In the backdrop of the above evidence, comma, a reference to the testimonies of, we can now turn to the testimonies of the other prosecution witnesses. Full stop. Like PW1 and PW2, comma, PW3, comma, Sukru Saura also deposed that he knew both the accused persons, comma, the informant PW6, Deepak Chaura, and the deceased. Full stop. As regards the incident, comma, PW3 deposed to the effect that on the following day of, on the day following the date of the incident, comma, the younger son of Veena Chaura, comma, Som Saura, PW1, informed him that his mother was lying inside the house. Full stop. On receiving the information, comma, he went there and found that many people had also gathered there. Full stop. He found the presence of the two accused persons at the place of occurrence. He stated that on the previous night of the incident, comma, the accused persons had put in the victim's house and they stayed overnight in the victim's house. During cross-examination, comma, PW3 stated that he did not know if the accused persons were present in the house of the deceased in that night, and his knowledge was, and he got the knowledge only in the morning from Som Saura, PW1. He stated that he did not witness the incident. Also, para. PW4. Veena Chaura stated that the two accused persons were from her village. Full stop. She also knew, apart from the two accused persons, she also knew the victim and the informant. PW4 deposed that she saw the accused from Taklu in the house of the deceased on the next day of the occurrence, Full stop. She was informed by Sam Saura PW1 that the disease was lying unconscious inside the house. Full stop. PW4 stated that she tried to wake up the victim by nudging her, but the feet of the disease were found closed, and the disease Bina Chowdhury with disease attack were found closed, and Bina Chowdhury did not wake up. Full stop. With the help of a lamp, PW4 noticed that there was blood on the bed. Full stop. She stated to have heard from PW1 and PW2 that the accused persons had killed the disease. PW4 was an witness to the inquest proceedings, and he exhibited the inquest report within bracket EXT2, which is signature therein as EXT11. Full stop. In cross-examination, PW4 stated that the diseased victim was a healthy person before her death. Full stop. PW4 stated that at the time of her death, his son, PW1, and his nephew, PW2, who were staying with her. Full stop. As regards the duration of stay of PW2 in the house of the deceased, PW4 stated that PW4 had been staying in the house of the deceased for a long time. PW4 further stated that she did not have any knowledge as to whether the accused persons were present in the house of the victim, but she saw them on the following day. Full stop. PW4 also stated that she did not see any injury on the body of the victim, but blood stain was noticed by her. Full stop. She claimed ignorance about the manner of occurrence of the incident. Full stop. Para. PW5. So Indra Saura. The accused persons, the informant, and the deceased were known to PW5, Sondra Saura, as they were her neighbors. Full stop. On the incident, PW5 reports that on the next morning of the occurrence, it was Sam Saura, PW1, came and informed her that his mother was lying with bloodstain. Body of the mother was lying in the house with bloodstains. Full stop. PW5 stated that she immediately went to the house of the victim and noticed bloodstain on the deceased and on the bed. Full stop. Thereafter, police personnel came and took away the accused persons to the police station. PW5 further stated that she did not witness any injury on the body of the deceased victim. Full stop. In cross-examination, PW5 stated that she did not know if the accused person stayed in the house of the accused on the night of the incident and how the deceased victim died. Full stop. Para. PW6, Deepak Chawda was the informant and elder son of the deceased, Bina Chawda. Full stop. Both the accused persons were known to him. Full stop. On the incident, PW6 reports to the effect that on the night of the incident, he was in his brother's house. Full stop. On the next morning and night, on the following day, his brother informed him that their mother's body was cold and she had expired. He immediately rushed to the house and found his mother's body on the bed. Full stop. Then his brother informed him that on the date of the incident, the accused persons, Momlu and Taklu, were present in the house. Full stop. Then, he went to Naholia outpost to lodge the FIR, which was written by a person named Foreign. Full stop. He exhibited the FIR as EXT2, which is signature therein as EXT21. Full stop. PW6 stated that he noticed the injury on the neck of his mother. Full stop. When this witness, PW6 was cross-examined, he stated that he did not know what was the contents in the Azahar and did not know how his mother died. Full stop. He further stated that he did not know when the incident occurred, as it was his brother who had informed him about the incident. Full stop. PW7, Dr. Saurabh Gujri Gogoi was on duty as demonstrator in the Department of Forensic Medicine, Assam Medical College and Hospital on 11/7/2016. Full stop. PW7 in his deposition, in chief, stated that he performed postmortem examination of the dead body of Bina Chawda at 12:45 p.m. on 11/7/2016 in connection with Naholia Outpost General Diary entry number 173 dated 10/7/2016. Full stop. In his he testified that after postmortem examination, of the dead body, he found the following, page 17. C to C. exhibiting the postmortem examination report as EXT 2 and his signature therein as EXT 21, PW 8 stated that his findings received concurrence of the head of the department, Dr. R.K. Lugwe, professor and head of the department, forensic medicine, AMCH. And the signature of Dr. R.K. Lugwe in the PME report is exhibited by PW7 as EXT 22. Full stop. He also exhibited the inquest report EXT1 and the dead body challan EXT3. Full stop. In cross-examination, PW7 stated that the injuries sustained by the deceased would also be accidentally caused. Right. It is noticed that the inquest proceedings was held in reference to Naholia Outpost General Gari entry number 173 dated 1/7/2016. Full stop. At the time of inquest, the formal FIR EXT 2 was not lodged by the informant PW1. Full stop. In the inquest report EXT1, it was recorded that there was an injury on the neck within bracket left side, and there was bleeding from the injury. Full stop. In the PME report, also EXT in the PME report, the which was performed at about 12:45 p.m. on 11/7/2016, the findings were recorded as under 56 B2B. There is no apparent inconsistency between the inquest report EXT so and the PME report EXT so. Both had reported that the disease had sustained an injury on the neck. Full stop. As per the inquest report, EXC Swenson, the injury was by sharp weapon. Full stop. As per the PMA report, it was a soft wound of size 15 into 15 cm over the left side of the neck up to the vertebral body deep over the side of neck. Full stop. Para. When the ocular evidence given by the two eyewitnesses, PW1 and PW2, are compared with the medical evidence in the form of testimony of the autopsy doctor PW7 and the PMA report EXC Swenson. Two. The evidence on the point of injury is found to be consistent that the disease had sustained the injury on the left side of the neck. What was the FSL report?
Lordship at page 69.
His age.
Age of
Okay. Major,
Major.
no dispute. Para. The ocular evidence of PW1 and PW2 as recapitulated above, is found to be consistent as regards the presence of the two accused persons inside the house on the night intervening 9/7/2016 and 10/7/2006. The two eyewitnesses, PW1 and PW2, had categorically deposed that it was the accused persons who had come near them when they were sleeping along with Veena Chawla in a room, and slit the neck of Veena Chawla with a dowel. Para. Learned MEC Curie have preparing for the two accused have strenuously urged that there was no recovery of the alleged weapon of assault from a DAO from the from any of the two accused persons. Full stop. The alleged weapon of assault from a DAO was also not recovered from any other place also. Whereas the two accused persons were all along present in the premises till they were apprehended by the IO PW 8. Post. Para. By condemning so, learned MEC Curie have sought to challenge the testimonies of the two eyewitnesses PW1 and PW2 as once ONES, which cannot be relied upon to return a finding of guilt against the two accused persons. Particular for the কালকে দেখাইছিল popular business appreciation group আপনাকে আটটা It is true that the appreciation of popular evidence is a difficult task, and there is no set yardstick for appreciation of oral evidence. Full stop. Acknowledging the same on sorry. Yeah. Having regard to the same command. The Federal Supreme Court in Sahaja. Ilyas Sahajan Ismail Muhammad Sheikh. Reported in 2022-12 SCR 186. After considering Tehsildar Singh, Tehsildar Singh, after considering a catena of decisions on the point, comma, has observed as an paragraph 27. Paragraph 27. Huh? Cross 2, cross. It is true, comma, as contended by the learned MECQD, comma, there is an inconsistency in the testimonies of PW1 and PW2 on a point. Full stop. While PW1 PW1 had stated that in the morning hours, comma, the two accused persons had gone away. After staying with them, bracket operator, PW1 and PW2, inside the house for the whole night. Goes on the other hand, comma, PW2 deposed to the effect that after staying with the two accused persons stayed with them within bracket PW1 and PW2 for the whole night. And they were present in the house till the arrival of police person. According to PW2 command, there was no effort. The accused persons did not run away, did not try to run away. Full stop. PW1 had stated that he had managed to go out of the house to inform his elder brother, comma, PW1 about the incident. Full stop. From the evidence of PW1 two and PW three. PW2 and PW2, PW3 and PW4. It can be noticed that these witnesses were also informed by PW1. Full stop. A question which arises from therefore is whether in view of such apparent inconsistency, the testimonies of the two eyewitnesses, PW1 and PW2, should be disbelieved despite their consistency as regards the manner of assault on Bina Chowra during the night by the two accused persons during the night intervening 9/7/2016 and 10/7/2016. Full stop. Para, it has been consistently it is settled that any discrepancy or improvement which does not materially affect the case of the prosecution and is not on the on a point, not on a point affecting the core of the prosecution case, cannot be made the basis for doubting the case of the prosecution. Because to the purpose, the court, a court of facts is not, should not concentrate too much on such discrepancies, any such discrepancy or improvement. Full stop. Having regard to the in this regard, from the following observations made in the decision in Korea and another reported in 2012, 10 SSC 432 may be aptly referred to para 30. Para. The other point which the learned MEC QD have contended is that there nothing incriminating could be recovered from the persons of the two accused persons and the same is a pointer towards their non-involvement with the crime. Full stop. It is contended that since the alleged weapon of assault was not recovered during the course of investigation, comma, the same has created a clear vital dent in the case of the prosecution. And in such view of the matter, comma, the accused persons should be afforded the benefit of doubt. Para. We have considered the above contention of the learned MSc query. And I have found after consideration from such contention is not acceptable, full stop. It is not an inflexible rule that the weapon of assault must be recovered. It is not a general and broad proposition of law that in case of non-recovery of weapon of assault, the whole prosecution case gets quickened, full stop. In Krishna Mochi and others versus State of Bihar, 2002, 6 SSC 81, now the Supreme Court of India has held as under quote unquote query. It has been then submitted on behalf of the appellants that nothing incriminating could be recovered from them, which goes to show that they had no complicity with the Crown. Full stop. In my view, the recovery of no incriminating material from the accused cannot alone be taken as a ground to exonerate them from the charges, more so when their participation in the crime is unfolded in ocular account of the occurrence, given by the witnesses, whose evidence has been found by me to be unimpeachable. Full stop. Software. In the case of State through the Inspector of Police versus Lali Elias Manikandan and another, reported in 2022, 15 SCR 633, it has been held as under. It has been held as under. Similarly, in the case of Prakash Singh, Kumar Singh versus State of Bihar, within bracket now Jharkhand, reported in 2019, 9 SCC 262, it has been held on the point of non-recovery of weapon as under. Underline for us. Another point that has been urged that from the evidence stored materials on record, comma, it appears, it emerges that the prosecution has not been able to show any kind of motive attributed to the accused persons behind the killing of the deceased, comma, who was incidentally an aunt of one of them. Full stop. Uh, it is the case in hand is not a case of circumstantial evidence, as there were two eyewitnesses in the form of PW1 and PW2. Full stop. There is no such principle or rule of law that where the prosecution fails to prove the motive for commission of crime, comma, it must necessarily result in acquittal of the accused. Full stop. When the ocular evidence is found to be trustworthy and reliable and finds corroboration from the medical evidence, comma, a finding of guilt can safely be recorded, even if the motive for the commission of the crime has not been proved. Full stop. It is a sound principle to remember that every criminal act was done with a motive, but its corollary is not that no offense was committed if the prosecution failed to prove the precise motive of the accused to commit it, comma, as it is almost an impossibility for the prosecution to unravel the full dimension of the mental disposition of an offender towards the person whom he offended. Full stop. Motive for doing a criminal act is generally a difficult area for prosecution, as one cannot normally see into the mind of another. Full stop. Motive is the emotion which impels a man to do a particular act, and such impelling cause need not necessarily be proportionately grave to do grave crimes. Full stop. Many a murder have been committed without any known or prominent motive, and it is quite possible that the aforesaid impelling factor would remain undiscoverable. Full stop. The absence of any evidence on the point of motive cannot have any such impact so as to discard the other reliable evidence available on record, which unerringly establishes the guilt of the accused. Within bracket reference. REF. Among Kumar, the state of Indian Territory and of Chandigarh, 2003, 6 SSA 380. It has been Uh, Section 34 over para. Section 34. IPC. IPC. Section 34 of the Penal Code has laid down that when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. Full stop. The principle laid down in Section 34 of the Penal Code is about a vicarious liability. Stop. The testimony of PW1 or as regards the assault, was to the effect that it was the accused, Monglu, who slit the neck of Bina Chawda with a dao. Full stop. In view of such testimony, the question, the issue, therefore arises as to whether the other accused person, Monglu or Taklu, can be roped in, can be is culpable for the crime with the aid of Section 34 IPC. Full stop. The Section 34 IPC is attracted when a specific criminal act is done by two or more persons in furtherance of their common intention. And in such a case, all the offenders are liable for the criminal act in the same manner as the principal offender, as if the act were done by all the offenders. Full stop. The scope and ambit of Section 34 IPC has been succinctly explained in the following paragraph of Tourist versus State of UP 2001 3 SCC 673 para 30. Para 30. How to determine is it not? It has unerringly emerged, conclusively emerged from the testimony of PW1 and PW2, coupled with the explanation provided by the accused, Monglu ne কোন আছে?
Page
Mong.
number 11. It was
Taklu. Taklu. In at the stage of in the stage of his examination under section 313 CRPC, that the crime was committed in the inner room of the house where PW1 and PW2 were sleeping alongside the disease, Bina Chawda. Full stop. The testimony was of PW1 and PW2 was categorical on the point that both the accused persons came from the outer room to the inner room together. Full stop. It has further, they had, from the testimonies, it has further emerged that when the assault was made, by one of the accused persons, the other accused persons were also present. Also, though no overt act on the part of the other accused person was attributed by the eyewitness, PW1, in view of the principle laid down in Suresh Supra.
Yeah, the overlay to the said traffic.
Awesome. All of change. PW1 the testimony of PW2 was to the effect that both the accused persons came to their room and caught Bina Chawda, caught hold of Bina Chawda. PW1 or PW2, PW2 bottom. Full stop. Both the eyewitnesses from PW1 and PW2 were categorical in their version that both the accused persons had threatened them not to disclose about the incident, and they remained present in the same room till the morning hours. Full stop. As there was overt act attributed to both the accused persons, it is, we are of the considered view that the principle laid down in section 34 IPC is clearly attracted in the case in hand. Having after meticulous evaluation of the entire of the testimonies of PW1 and PW2, that two eyewitnesses, we are of the clear view that their testimony have a ring of truth. Their testimony on the point of assault on the disease by the two accused persons have a ring of truth. Post in such view of the matter, the inconsistency, pointed out by the learned amicus curiae, which were on the events after the morning hours, are not of such significance to discard the core of the prosecution case. For the foregoing discussions and thus, in view of the above discussion, more particularly, the after thus, after meticulous appreciation of the materials, evidence from materials on record, more particularly the ocular evidence, or more particularly the eyewitness accounts of PW1 and PW2, and the medical evidence in its entirety. We are of the considered view that there is no good and sufficient reason. There is no reason, much less good and sufficient reason to depart from the view taken by the learned trial court on the point of guilt of the two accused appellants. Full stop. Resultingly, we accordingly hold that there is we accordingly affirm the judgment and order of sentence and judgment and order of conviction and sentence passed by the learned trial court in sessions case number so and so, resultingly, this criminal guilt being devoid of merit, fails. We'll discuss about the three judgments you have referred to. Records, amicus appreciation of both N.K. Borua, R. Sharma. Are records.
Item number for next item, maybe I have any other.
Next item, all of you should have. Okay, next item.
My lord,
For that one,
my lord,
volume,
appeal against acquittal, my lord,
for appeal against acquittal, item number 4.
for my lord,
Who is the counsel?
my lord,
Who is the counsel for the appellant? You are.
my lord.
Appeal against acquittal.
My lord, my friend Mr. Sharma, my not his enemy, now he filed the appeal, my lord. Later on I have,
You are running against the tide.
my lord,
Okay, after vacation.
my lord.
Over for the
My lord, for the private,
Private.
the respondent, my lord, accused them appeared, my lord.
okay. I am Sharonia, learned counsel for the appellant. MS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. And MS M. Das, learned counsel for the respondent number 5 to 12. Anybody for 2, 3, and 4?
Mr. Soikia.
As requested by the learned council for the parties from a list appeal. After the ensuing summer vacation on a date to be fixed by the office.
My lord. I live.
May I please, your lordship? Item number 10, lordship. 302 case, lordship.
Nothing before vacation.
So after vacation, lordship, a date may be fixed kindly, that will help us.
No, dates are fixed according to the period of detention. How much?
It's around 4 years, lordship.
4 years.
2019, 5 years, lordship, around 5.
Must be less than this. Others are above you are 5 years, 9 months, etc. So accordingly, it has been listed. Okay, after in the month of July, I'll say.
Lordship,
Okay, Mr.
Kedas, lordship.
Adas. Learned counsel for the appellant. And MS A Begum, learned additional public prosecutor for the respondent statements are present. Post of list the appeal in the month of July on a date to be fixed by the office.
Lordship.
Has sought for.
Obliged.